Our next topic is labor procedure. What is labor procedure? Your bar syllabus tells you to master jurisdiction and remedies. Well, these are parts of labor procedure, really. So, labor procedure is simply the means by which the power to hear and resolve labor disputes is conferred, acquired, and exercised, resulting in a judgment, including the means by which to challenge such a disposition. So, that's the basic concept of labor procedure. And so we shall be covering the following aspects. Number one is jurisdictional rules. Number two is conferment of jurisdiction. Number three is acquisition of jurisdiction. Next is exercise of jurisdiction. Then judgments, appeals, and then enforcement of judgment. So if you know all these aspects, okay, more or less you're ready for labor procedure, especially for jurisdiction and remedies. So let's tackle jurisdictional rules. When a dispute is brought to a particular labor tribunal, just how do we know that that tribunal, office, or agency has the authority, the power, or the competence to hear and to resolve that case? Well, we apply two basic jurisdictional rules, namely the reasonable causal connection rule and the sole reference to labor law rule. The reasonable causal connection rule and the sole reference to labor law rule. The first rule requires you to know the origin of the case or the dispute. Okay? Does the dispute have a reasonable causal connection to employer-employee relationship? In other words, is the origin of the dispute employer-employee relationship? If the origin were some other legal tie, like an independent contractorship, like a civil affair between a creditor and debtor, between a lessor-lessee, between a vendor and vendee, if the affair were a partnership, then the dispute should be brought elsewhere for resolution. It should never be brought to a labor tribunal. So we have to distinguish between several legal ties. Okay, so we should know when employment tie exists. We should know when other ties exist. In the meantime, the second rule, which is the reasonable or the sole reference to labor law rule, requires that the case be resolvable through the application solely of labor law. That means only, that means exclusively of labor law. So that if the case were resolvable through the application of other laws, then it's time to entertain bringing the case to court or to some other body for the purpose of resolving it. So those are the twin jurisdictional rules. So back to the first, which requires us to revisit principles, rules pertaining to employer-employee relationship. How do we determine that legal tie known as employer-employee relationship? We go back to basic rules. We go back to the fourfold test. Now actually, the heart of the fourfold test is the control test. Understand the fourfold test has four component tests, namely the selection test, the wage test, the dismissal test, and the control test. And of these four component tests, the most important test is the control test. We know that under that test, it is pervasive control over means and methods of performance that determines employment tie, which tells us to revisit also other types of control. Indeed, there are other types of control that indicate other types of affairs, legal ties, or relationships. So, again, what determines employment tie is labor law concept of control, which is pervasive control over means and methods of performance, manifested basically by supervision, okay, manifested by plant rules, which called for disciplinary action in the event of breach thereof, and other manifestations of control. Now, we have seen through the years other types of control, like the control detected by the Supreme Court in the old case between ABS-CBN and J. Sonsa was the so-called post-production control. In the case of Orozco versus PDI, the control detected by the Supreme Court was editorial right. In the case of Gregorio Tongo versus Manulife, the type of control seen by the Supreme Court was built-in control in insurance. In the case of Nestle, it was sound business practice. Now, in 2, 3, 4 cases involving churches, the type of control seen by the Supreme Court was church governance. And so we have to be aware of these other types of control, because if any one of them is the type that is in attendance, okay, or that obtains in the problem, then we should be ready to rule out employer-employee relationship, and that is how we know where to bring the dispute. Should it be brought to court? Yes, if the source of the dispute were an independent contractorship, were a civil affair between a creditor and the debtor, a lessor and lessee, a vendor and vendee, or if the source were a partnership. And we have cases now that illustrate these other types of affairs. Now, the basic tests that we employ to detect employment tie